You can see my contacts scrolling through my ticket. Good morning, Mickey on YouTube. Welcome. Good morning. All right, so we can talk. If you have questions, definitely pop your questions in while I am getting my other streams up and going. And then as an FYI, for those of you filing, as of yesterday, there's a new I-765 form. That's a new EAD work permit form. So, you want to start using the new one. Granted, they will still accept the old one up until March 1st. But, if you haven't submitted, you might as well just use the new one now. Someone says, good morning. I missed your live yesterday. Quick question. Does this new rule affect a 40-month-old VAWA still married? What new rule? Which, you'd have to specifically reference what rule you're referring to. My parents filed their U visa together in January 2024. My dad got his work permit in January 2025, but my mom only got her bona fide letter, no work permit. What can be done? Well, without knowing your parents' case, I can't answer that. I don't know. Did they file independently? Was she filing as, a joint filing as a spouse? What did they submit, for their work permit? So I would need to know some of that to be able to answer your question. Kenoa is asking, my VAWA was approved in March. How long before I can get my green card? The answer is going to depend on what country you're from. Obviously, with the new adjudicative hold, any question that I'm asked, I would need to know what country you're from to be able to tell you what to kind of expect. All right, let's see what else we have here. I strongly recommend her for your immigration matter because I have personal experience with her firm, which exceeded my expectations. She's so detail-oriented and passionate. Thank you so much, Sunnison. I really, really appreciate that. Kenny Bruss says, do you work pro bono? I do. I do pick cases that I'm deeply passionate about their story, and I do it for those people. Yeah. J-Rod, good morning. Ms. Gorgeous Queen, how are you doing today and how are you feeling today? I'm blessed and have favor. I'm doing okay today. Okay, let's see. What else? Power says, please, does the partial hold of naturalization process affect those in the military? Yes, yeah. The hold is for the 90 days, affects everyone as long as you're from that country for naturalization. Hopefully in 90 days, they will be able to then tell us how they're reviewing and processing that. They're creating I guess an additional vetting process for security and, trying to prevent fraud and all of that stuff. So we'll see. I can't answer how long work authorization takes because I don't know what your case type is. And it also depends on your country. If your country is on the list, I can't tell you the answer to that because nobody knows. No one can tell you the answer to that until the 90-day hold is removed. And then we see what, is happening. Okay, yeah. So this person is asking about the partial ban and if you already had a valid case. Yes, it does include what I said yesterday is exactly what it is. If you are from those countries, with the exception of those applying for a renewal of their green card, and some other limited exceptions, you will be facing an adjudicative hold. What does an adjudicative hold mean? It means that there is a pause on them approving or denying your case. Well, let me just actually focus on approving because to a certain extent, the language reads as though if someone has a crime of moral turpitude or whatever they consider inadmissible, that they have the discretion to deny that. But as far as an approval, they are going to pause on that for 90 days. One of the things that I said yesterday, and I have more updates today, was, as far as it relates to interviews, that what we may see is that some people's interviews will be canceled or some people attend the interviews. So I can confirm that one of our clients who's of Nigerian descent, yesterday we contacted USCIS because they have an interview coming up, and they were like, they will proceed and continue with the interview for that person. So, so that is to say, I don't necessarily know yet, how each field office is going to handle this, whether each field office is going to be uniform in this, but either way, if you fall into one of those categories, I would recommend that you check your case status every day up until you speak to them. Either you speak to them on the phone and they confirm that they're not canceling the interview, you should still come to the interview, or that if you're not able to reach someone on the phone, check your case status online up until the day of your interview so that you know if they canceled it or not. So, what this tells me is that they're most likely, since this person, this client or couple are going to the interview, that they are still largely still interviewing them. They just will not make any decision until directives are given. But again, this is just one person. So I still need to see a few more people to be able to tell you whether it's 50-50, whether you're being scheduled for the interview or whether they're just saying pause on the interview. To me, it makes more sense for them to do the interviews, just because the backlog or the delay is going to be ridiculous. Because, you can do the interview and then just make the decision once you have whatever the requirements to make the decision is. So we'll see, though. I will keep you guys updated as I find out more. Okay. Let's see what else I have here. Kenoy, you are literally spamming my YouTube. You've asked me the same question like 7 times and I've answered you. So I don't know if you can't hear the answer or what's going on with you. Okay. Good morning. If you pivot at a marriage-based interview and they just kept your VAWA packet and issued an RFE for an updated medical, do you think I can still get approved while I-360 is pending? I can't answer that question unless I know your case type. I don't know your case type, so I can't answer that question, unfortunately. I had my green card interview canceled because my wife is in the military, and I told them that she's being deployed and the interview was canceled. Is there anything I should be worried about? At this time, I would say no. Because if you're going for a marriage-based interview and your spouse can't attend, officers are at their discretion. Sometimes they're able to, if you have like really strong bona fides, good proof of good faith marriage, sometimes they're able to do it without you. They have those exceptions for people in the military that are deployed, or people that are actually in prison or jail, whatever it is. But, if they've canceled it because they want both of you there, then that's fine. Can we get notices for biometrics despite adjudicative hold in effect to countries in the list which I belong to? I don't see any reason why you would not get your biometrics notices, just because, remember, this is a pause on decision. So let me make sure you understand, a receipt is not the same thing as a decision. So your receipt is fine. It's just a pause on them making the decision for the next 90 days. But again, it's only been 4 days, what's today, the 6th, the 5 days. So as we find out more, we'll definitely share, or at least I will share as much as I can. Does anyone who gets married to a green card holder, are they eligible for a permanent resident? Well, you are eligible for permanent resident application, but are you eligible to be approved? Then that's a different story, because there are just so many nuances to being married to a green card holder to determine eligibility for approval. So nobody's stopping you from filing, but the question is, are you eligible for approval? So there are a few things that they would look at to determine eligibility. If you're married to a green card holder, the first question is, where are you? Are you in the United States or are you outside the United States? That's number one. If you are outside the United States, not a problem. You're going to go through consular processing and just wait for the visa bulletin to be available for you to finish your process. If you are in the United States, they're going to be looking at is the visa bulletin current, meaning there's a visa available for you to get your green card? Number two, are you in status at the time of application, and did you violate? You know, when you're married to an LPR and you're in the United States and you're trying to adjust your status, you absolutely cannot have any immigration violation. You cannot have worked under the table. You cannot have overstayed. You cannot have you cannot have any immigration violation. You have to be in status at the time of application, right? That is the only way if you're doing it based on marriage. Now, for instance, if you're married to an LPR and then you become a victim of abuse or whatnot, that changes, right? Because even if you're an overstay, they make an exception in that category. Or if, let's say, you worked under the table, like they'll forgive you for working under the table, but you have to be honest, about it. There are a lot of times where, people want to omit certain things, and it's silly because, you're better off being honest so that you can show credibility and explain whatever it is, especially when it's something that you're not going to be penalized for, or there's a forgiveness or a waiver for it. Steve says, my VAWA is 7 months and no receipt notice yet. What should the next step be? Honestly, if it's 7 months, it means that you submitted your VAWA before September of 2025, and any application for VAWA that was submitted before that experienced an extraordinary amount of delay, more delay than we've ever seen, in the history of at least me practicing, which is why they opened multiple processing centers to now take receipts, which has its pros and cons. Yes, receipts after September are faster, but we're seeing a lot of mistakes. And sometimes that's what happens when you just kind of like create all this and they don't really train them on, VAWA, or sending it back saying we need a filing fee, because these people are used to collecting filing fee, and them not understanding that, with the VAWA case, there's no filing fee. So 7 months is not unusual. That said, you can reach out to USCIS to check on the status of you receiving a receipt, just to make sure that your file actually did get there. And hopefully they'll get back to you. Sometimes when we send inquiries to USCIS saying, it's been a while, and we've not gotten a receipt for a client, usually USCIS will, they may not reply us, but within like 3 weeks, 4 weeks of that email, we'll usually see a receipt. So hopefully that's what happens for you. Okay. Let's see what else. Can a Nigerian living in the United States, married to a U.S. citizen, file for a green card? Anyone that's married to a United States citizen can file for a green card. Now, if the question is from an eligibility standpoint, you can file, but how your case is processed, all of you guys are kind of asking the same questions, but the answers depend on your entry. How did you enter the United States? So let's assume you came from Nigeria and you entered with a visa. You marry a United States citizen. Yes, they can file for you. Although right now, as a Nigerian, filing, if your Nigerian passport is the only passport you have, you can file, but when it comes to decision time, let's say your decision is in the next 90 days. They're not going to make a decision until after the next 90 days. So it is possible, that if you filed now, most cases take, 6 to 13 months. So by then we would know how they're processing these cases. But the simple answer is yes, you can file, if you entered with inspection. If you didn't enter with inspection, meaning you crossed the border, you can file an I-130. That said, in this administration, if you cross the border and you just want to do an I-130, I think it's very risky. I wouldn't do an I-130, because you want to do an application where you can do an I-485, and you're not eligible for an I-485 if you cross the border during a marriage-based case. So hope that helps. Should I delay my submission of documents for consular processing due to the partial ban for Nigeria? Absolutely not. You should put your submission in so that you can be on the line. Do you understand the backlog that you're going to experience once this is removed? Put your stuff in and get documentary qualified. Because once you get documentary qualified, what will happen is that for all of you guys that are outside the United States, that are part of the countries that have the ban now, and you're in that phase, the National Visa Center phase, what you can do is every let's just say it takes a year or 2 years or whatever. I'm just throwing this out there. You can request every year for them to keep your file open because you're waiting for them to lift the ban, but that way you stay in line. Because if you don't stay in line now and you're trying to get documentary qualified, let's say to take out the ban a year from now or 2 years from now from consular processing, then that's where you be in the line, and everybody else that's submitted between today and 2 years will be ahead of you. So if you're already at consular processing, submit everything at National Visa Center, okay? Okay, guys, let me just block this person that's using profanity. Let's see. I answered that question already. You worked on my case 3 years ago and it was amazing. We'll be calling your firm this week. God bless you. Oh, thank you so much. I'm glad. I'm really glad. I'm so low energy today, guys. Okay, my sister's a VAWA applicant. She got several prima facie, Social Security, work permit. Can you say if she's at flight risk, what's taking place with TSA supplying your info to ICE these days? If she has a VAWA application and her Social Security number and a work permit, she should be able to fly. She has because she has that pending case, so she's fine. And hopefully she doesn't have any criminal records. Any ideas on processing time for F2B visa that started from VAWA? Biometrics were completed about 3 months ago. Country Jamaica. What do you mean F2B visas that started from VAWA? Like, I don't understand what you mean by that. Like, F2B visas, what? Like, I don't understand what you mean by that. Like, if you can provide more clarity. Because F2B would be a child that's over the age of 21. So what are you talking about for an LPR? So are you saying like parent is an LPR through VAWA and then the child, they're sponsoring the child, or the child came under the parents? Like, I don't understand your question. Can I travel to Jamaica with my travel and work permit? The answer will depend on your own particular immigration history. It's very difficult for me to answer travel questions because I don't know your immigration history, so I can't answer the question. But for most people, if you're not from a banned country and you don't have any criminal records and you have a work permit or travel permit, you usually are able to travel. But the answer also will depend on what stage your case is in, because certain stages, I don't recommend traveling. What happens if my current prima facie has expired? You will get an automatic renewal. You don't have to do anything. This can often take sometimes like a couple of months, like meaning they're very notorious for sending those late, like 2 months later, 3 months later, but they will send it. Can I file for my parents with my green card? No, you have to be a U.S. citizen to petition for your parents. This is a good question. With immigration freeze, Will extensions be given if you file for removal of conditions? I anticipate they will be, because an extension is not a decision. It's literally your receipt. So I expect that you should be given your receipt notices, which have the extensions. If I get divorced waiting for my 10-year green card, what's next? I have 2 years waiting for the 10-year green card. This is a very, very, very important question, and a lot of people find themselves screwed because of the decisions they make at this phase. The question this person is asking is, if they apply for a 2-year removal of conditions, like they have a 2-year conditional green card, and they're applying to remove the conditions on their green card so they can get the 10-year, and they get divorced during the time while they're waiting. The question is, well, what do I do? You must, let me say that very clearly, you must notify USCIS that you're divorced and that you need to amend your joint filing for your removal of conditions to now request a waiver on the basis of divorce. This is not optional. If you don't do this, you are going to have a problem at naturalization and possibly have your green card revoked. Like, I cannot stress this enough. I have had people who I told this didn't listen to me. They're like, oh, well, I got my green card, and come back and want to naturalize and somehow believe that the problem will go away. And I said, this is why I told you then, amend this. So please make sure you amend it, okay? Because if you're approvable as a joint filing, you will still be approvable as a divorcee. Remember, when you are filing a waiver based on the divorce, there are only 2 critical things that you need to show. The 2 critical things that you need to show is that, 1, your divorce has in fact come through, meaning they finalized your divorce. Number 2, that you have proof that your marriage was a genuine good faith marriage. So the same evidence that you would submit anyway for a joint filing, okay? Is it safe to renew my 10-year green card? I'm from Libya, which is listed on the ban country. I'm in the US now with my family. Yes, renewal of green cards is an exception to the adjudicative hold. So you can submit your I-90 and you should be able to get a decision on your I-90. So that's fine. I mean, you can submit it in any of the cases, quite frankly. It's just that for other cases, they're not going to make a decision. But if you already have a 10-year green card and you're filing for renewal of your 10-year green card, you would be one of the exceptions where they can make a decision and, renew your green card for you. Okay, it's like my what if you get the person gets a 10-year green card and then divorce before filing for an N-400? That's different. If you have a 10-year green card and then divorce after, that's different from the question the other person was asking, or if you're the same person, because then that doesn't matter. But you have to understand that a 2-year conditional green card based on marriage, the basis on which they're giving you a 10-year when you do a joint filing is because you're applying saying that you and your partner are married. And so it is important that you correct that and amend that. But if you got your 10-year green card and then after you got your 10-year green card, you got a divorce, then you're okay. All right. All right. Let's see what else. My friend is married to a U.S. citizen and she filed for him and his 3 children over 24 months ago. They got their work permit and Social Security over a year ago, and they still didn't get their green card. What can they do? Well, one, we'll need to know, well, what country are they from? That's number 1. Number 2, 24 months is definitely a long time if they are not from one of the countries on the temporary hold. I would say this would be a good time to definitely reach out to USCIS, possibly congressional assistance, possibly a mandamus, only if their case is like super strong. Dominique says, I've filed for VAWA since September of 2024. I've received my work authorization, but no prima facie yet. What does this mean? It means that your case is not prima facie eligible. So you need to reach out to USCIS to send you an RFE of whatever is missing so that they can complete, so that you can, fix it so that they can issue a prima facie. It is also possible that they issued a prima facie that was just not mailed out. Like we've had that where we're like, oh, it's taking a long time to get a prima facie for this person, and it turns out that USCIS just forgot to mail it, or maybe they mailed it and they sent it to the wrong address. I can tell you that they're very notorious for doing that because, sometimes we receive other people's, like other law firms, like mail, and I'm like, this is not from our firm. Or sometimes others, it's very rare, but I've had one or two times where, like another firm received our mail and they sent it to us. Okay, let's see. Do I have to file for removal of condition by waiver before the 90-day reminder, or can I file after? I'd like to know the consequences if I don't file before. So this is also a good question. You guys have a lot of good questions today. When you are filing for removal of conditions, the earliest time you can file for removal of conditions on your 2-year green card, if you're filing based on a joint marriage, is within the 90 days. So you want to file within the 90 days, no earlier than 90 days. Now, if you are filing on the basis of a waiver, you can file it as early as you want, even if it's 2 days after you got the 2-year conditional, or you can file it as late, as you became aware. Not saying that you should sit on your file and file it late, but if you file it late, they will still accept the late filing. That said, if you have the opportunity to file it on time in this administration, because this administration, even though I haven't personally seen anyone being NTA'd, when I say personally, I'm talking about in my own practice, I can't speak for anybody else, when they've done a late filing in this administration. But basically, the position I take with everyone and what I come here to teach you guys is, don't leave anything to chance. This is one of those dot your I's, cross your T's, whatever you need to do to make sure you keep yourself, in status, or basically not make yourself a target, but the rules do allow for you to have a late filing, to answer your question. Amia said, is getting married for a green card still a thing? It was never a thing. That's fraud. You don't marry someone for a green card. You marry because you want to get married. And if they are citizens or green card holders and want to file for you, they can. So I'm not really sure what your question is asking. What is the difference between mandamus and Congress? Congress is when your senator or congressman basically is reaching out to USCIS, if a case has passed processing time, or there's a reason why you need an escalation, just to see, well, what's going on, how much longer is it going to take, this is one of my constituents and, this is affecting them. Mandamus is an actual lawsuit. It's like a lawsuit, you versus the government, like you file you versus the government. You file a case in federal court saying that, they unjustly, delayed my case for X, Y, and Z reason. So that's the difference. Okay. I will have to jump off right now. I know I had said that I would come on live tomorrow, but as I see, I have a USCIS interview because, those are very unpredictable. So I have to be at USCIS for an interview tomorrow. So I wouldn't be live tomorrow. But if you have any more questions, definitely call us, schedule a consult, 407-995-6567 or 678-325-1037. You can also send a message on WhatsApp, 404-333-8751, or send us a DM, with your contact information so we can reach out to you guys. I hope you guys have a good day. Bye.